Ananda Sen, my Lord Justice Jayamala Bagchi, my brother, sister, colleagues, judicial officers across the state, a very good evening and welcome to this distance participating learning program in which we are holding this second webinar. In a time when distancing has become the norm, we are today living in a time when distancing has become the norm. The challenge is to bridge the distance with the aid of technology and keep the flow of interaction and exchange unimpeded. It is against this background that my Lord Justice Ananda Sen took this initiative that we cannot afford to shut down the arteries and veins of interaction to dry down. And under his Lordship's initiative, we are holding today's program on facets of criminal trial. It is on a very heartening note, I want to add that we have a very eminent speaker today, the main speaker, in Honorable Mr. Justice Jayamala Bagchi. We remember very shortly in the month of December, if I am not wrong, His Lordship was here in a cyber conference, and in October 2019, His Lordship was here in Jharkhand in our Judicial Academy, and we had the privilege to hear his profound thoughts and incisive comments regarding the nuances of criminal law. So at the outset, I must thank His Lordship to accept our invitation to address all the officers. And today we have all the principal district judges from the state, all the district judges, District Judge 1, and all the officers from Kodarma Judgeship. Now we understand, as everyone will agree here, that criminal law, when we say, it is a very vast arena, it is a vast field. And as for our brother and sister officers, I must confess that this time slot is too brief a period to cover the entire subject, because the nature of crime is changing, the modus operandi is changing, and therefore is changing the challenges before the courts. So when we talk about trial, it starts from framing of charge. But framing of charge itself has many intricacies. Alternative charge, when we talk in terms of 302, 306, 304B, 376, then we have amendment of charge. So, and then there are many related issues. But without taking further time, because we understand that time, we are short of time, and we will request my Lord Justice Ananda Sen to give his introductory remark, and after that His Lordship Justice Bagchi will be deliberating and on the topic. Thank you, sir. My Lord.
Thank you. Thank you, Mr. Chaudhary, Director, Judicial Academy. First, I would like to thank our Chief Justice and Justice A.C. Mishra for giving me this opportunity to hold this webinar. Without their cooperation, this couldn't have been done. Today's webinar is on facets of criminal trial. And there cannot be a better speaker on this issue than Honorable Justice Jayamala Bagchi of Calcutta High Court. Facets of criminal trial. The horizon of this topic is never ending. No matter how deep we dive, this topic will not reach to its bottom on the floor. A very small aspect makes a huge difference. We may ignore a minute process or a minute aspect, but later on, we may find that the said process and aspect which we ignored has tilted the balance of justice and later on injustice is caused. The cardinal principle of natural justice is embedded in every step of our criminal justice delivery system, starting from framing of charge till pronouncing of the sentence. Framing of charge, recording of statement under section 330, hearing on the point of sentence are very important procedure which cannot be taken lightly by the trial courts. Our esteemed speaker will definitely address these issues. Friends, another issue which I would like my senior brother Bakshi to throw light upon is the rights of the victim in a criminal trial. The general notion is that our system is heavily loaded towards the accused, but the victim or the witnesses do not get equal platform in a criminal trial. Though of late, I am to say that by several amendments of CRPC, some rights like right to appeal, victims, compensation, etc. has been incorporated. These things also I request my senior brother to address upon. Another aspect is the effect of compromise in a criminal trial. As a judge, we come across several compromise petitions which is being filed in a criminal trial. That too in heinous offenses. Offenses like 304B of the IPC, 376 of the IPC, even in POCSO, we are seeing that a joint compromise petition is being filed. The trial court must be in a dilemma as to how to deal with these type of petitions. I would therefore request Justice Bakshi, if possible and time permits, to address this issue also. I will not take much time. You all are eager to hear him. He is such a speaker for whom at least I am ready to walk few miles to hear him. Thanks for the COVID and thanks to the technology, we are hearing Justice Bakshi live from our respective residence. Now I hand over the proceedings to Justice Bakshi. Thank you.
विजुअल नहीं म्यूटेड है यहाँ कर दिया उनको प्रेजेंटर बना दिया है
and the director of the academy and the deputy director, I presume, and all the learned judges of various districts in the state of Jharkhand. Judicial Academy Jharkhand has been very kind to me, and I have had number of occasions of interacting with the honorable judges of the Jharkhand High Court as well as the Judicial Academy in different educational and research exercises. Particularly, as Mr. Chaudhary spoke, I fondly remember the cyber crime project, which was undertaken under the leadership of the Jharkhand Judicial Academy to bring to light that it is not advancement of technology alone, but various other sociological factors which play an important role. And one of the backward districts in the country was in fact the hotspot for cyber crime, namely Jamtara. And that was an experience for me to learn and see how the research from the end of judicial academies can be undertaken and effectively projected for development of law. Coming to the present topic, namely that is the facets of criminal trial, I completely agree that it is almost taking a dip in a vast ocean. But I would like to really address more the evolutionary dimensions of criminal trial, particularly in the last 2 decades of the 21st century, of this century. The classical idea of criminal law was best portrayed perhaps, in the words of one of the leading American jurists and Supreme Court Justice, Felix Frankfurter, who stated that the history of liberty is largely a history of procedural safeguards. I will make a little extrapolation from that observation and say that the history of criminal law is essentially a history of procedural safeguards. And when I say this, I essentially assert and try to make this point that the development of law, particularly criminal law, and in effect criminal trial, is the ensuring of the fair trial rights which are available to an accused. And the reason for the foundation of such basis of criminal trial, in fact, goes back to maybe 800 years, if not more, to the Magna Carta, where the idea of deprivation of liberty was essentially founded on a charter of rights which were available to the individual who was who was charged with a criminal offense which would amount to such deprivation. The fair trial rights and the fasciculi of these fair trial rights therefore became the bedrock of development of criminal law and criminal trial in particular. The essential importance, or the primary importance, in seeing an effective criminal trial being conducted was to ensure that the fair trial rights are to the accused and thereby justice is achieved. However, the passage of time saw a very interesting development in the impact of fair trial rights simplicity being assured and effectively enforced. I give an example here of one of the very recent incidents or the cases decided by the Supreme Court. 26 years after a case involving murder of 4 persons and injury to a large number of individuals, ultimately rested in the Supreme Court, where 7 people had been convicted. During the hearing of the appeal, a bench of the Supreme Court acquitted those 7 accused persons on the ground that the charges framed against them were not proper. One of the basic fair trial rights, which Mr. Chaudhary pointed out, was framing of charges. In this particular case, although 3 persons had died, only a single charge had been framed involving all the accused persons by applying Section 149 of the Indian Penal Code, which is the collective responsibility of a member of an unlawful assembly. Dealing with the evidence on record, the Supreme Court in that case held that the evidence did not, and there was vague and non-specific evidence with regard to individual acts. The Supreme Court also held that failure to frame individual charges, in fact, has sounded a death knell to the criminal prosecution. We have heard of cases where the prisoner escaped because the policeman bungled. This case in Binu Bhai versus State of Maharashtra, State of Gujarat, which was decided in 2018, was one of the unique cases where the accused escaped or could not be convicted because the judge bungled. The judge did not frame the charge separately for the murder of each of the accused, each of the victims. Individual offenses, individual charge under section 302 simpliciter was not framed, and finally there was an acquittal. One would wonder that why the Supreme Court in this case did not remand it for retrial by reframing with a direction for reframing of charge. The court, however, was not in favor of a retrial, keeping in mind that a quarter of century had lapsed, which again is a telling impact on the delay, which is a chronic difficulty in administration of criminal justice and maintenance of fair trial rights, both to the accused and to the victim. This is one instance which I thought of sharing with all of you as an unique example where fair trial rights and its failure to maintain at the right and the opportune moment create a proverbial loss of the real initiative to justice. A stitch in time saves 9, and a failure to do so would perhaps not be remedied by 100 stitches. And therefore, the necessity of ensuring the fair trial rights of an accused, and that too at the very ground level, that is the courts of first instance, is one of the most important prerequisites of a just criminal justice delivery system. This brings us to another interesting area, that is, what are the fair trial rights? Are the fair trial rights today only the premise of an accused? Or, as Justice Sen pointed out, the fair trial or the idea of just trial not only envisages a fascicule of rights, as I said, which hark back 800 centuries ago and have become not only the fundamental rights of various nations, including our countries, but the bedrock of human rights enshrined in various international covenants. But an important area to be deliberated upon is, where do the limits of these rights go? Do the rights remain a domain exclusively dedicated to the interest of an accused charged of a crime, or the fair trial rights would envisage rights of a victim, rights of witnesses, and finally, the ultimate right of society to be the audit for all that the judges and the justice delivery system does. And this is the area where the facet of criminal justice and the facets of criminal trial have seen perhaps the most interesting evolution in recent years. As my brother Anando Sen pointed out, there is always a silver lining to every dark cloud. The pandemic attack, which has restricted all of us to our residences and prevent us from coming close together, create and throw up interesting questions in law. One of the fundamental rights of fair trial is trial in an open court. Or in other words, a right to a public trial is one of the fundamental premises of fair trial. Although we have been conducting our court proceedings online and through virtual hearings, there has hardly been any instance where a criminal trial has been conducted through virtual hearing or online process. it may be interesting to deliberate as to whether, if at all, under certain circumstances, extreme as the present one, a court is called upon to do a virtual trial or a trial online. Will it subscribe to the idea of open justice and open trial? It may be interesting to note that perhaps last week, the Supreme Court in Singapore pronounced through an online judgment a death sentence to a drug trafficker. Whether or not such pronouncing of an extreme penalty without permitting a convict to appear in person physically before a court is a violation of human rights or amounts to denial of fair trial rights is an interesting legal question which we may deliberate. But apart from the extremity of a capital sentence being pronounced on a virtual court hearing, there have been instances where bail hearings of preliminary nature, which have taken place in various jurisdictions throughout the world, including India. In India, we have, in most of the states, including the state of Jharkhand and my state, we've continuously and regularly done bail hearings through virtual courts and online processes. Whether these hearings were in consonance to fair trial rights may be a matter which we can deliberate. A right to open trial or an open court proceeding is not only a constitutional, is a basic human right, and is also a statutory imperative which was recognized as a part of a fundamental right under Article 21 in Mirajkar, a constitution bench judgment of the Supreme. However, in Mirajkar itself, there are exceptions which were engrafted, that if extreme conditions, and in that particular case, a law and order problem arose, open trials may be substituted by in-camera hearings. Not only in-camera hearings were prescribed for open trial, but also in-camera hearings were prescribed for situations where the availability of accused and witnesses were not always the interest of witnesses and victims were at stake. Statutory provisions were therefore engrafted with regard to offences against women, particularly sexual crime, and offences against children under POCSO Act, where the trial in an open court, accessible to all, including the accused, was restricted in favor of the interests of the victim or in favor of the interest of the society to maintain law and order. If one sees the development of the pandemic from that premise, the interest of the society to maintain public health and maintain the hygiene and safety, public safety of all, are relevant considerations to shift the proceeding from an open court scenario to a virtual hearing domain. However, when one goes into a virtual hearing domain, and this, as I can point out, is not something which is wholly unknown, even wholly unknown in earlier times, in earlier instances. It would, however, have to ensure certain basic safeguards with regard to primary requirements of natural justice, and fair procedure. The first and foremost idea of natural justice and fair procedure is the access to justice, and therefore the familiarity and access to technology by all the stakeholders who have an interest in virtual hearing processes. In United Kingdom, in a court of appeal decision in respect of family court hearing through virtual media held that to ensure the fair procedure in remote hearings, as it was described in that proceeding, would include the access, the familiarity, and the access of every party to the technology and to the technology and other aspects of use of such technology to make such hearing fruitful and permissible in law. The Court of Appeals further held that the right to consult a lawyer, confer with a lawyer before, during the hearings must be ensured to have such a proceeding just, fair, and reasonable in the eye of law. Similar principles require also to be incorporated when we see virtual hearings in our courts today. We have to therefore see that the public hearings not only partake a case of mechanical disposal of proceedings and a matter of fact routine passing of orders, but effective and proper access not only to technology, but also the familiarity to the use of technology, both for the stakeholders, namely the parties and their lawyers. The fair trial procedures, as understood in foreign jurisdictions and abroad, also mandate certain protocols which may be relevant for our consideration. One of the protocols of fair trial hearing may be recording of such hearing for the purpose of post-hearing streaming in the websites of the courts. It can also involve an audio-visual display on a live streaming in the court websites or any other websites which may be utilized for that purpose. The aspect which is most important, therefore, in every hearing is the access to justice and the participation of every individual through himself and his lawyer in an open court proceeding. In a court proceeding, be it in an open court premise or virtual court meeting. As I pointed out, the virtual court hearing or hearing through video conference was not unknown to Indian law hitherto. In Praful B. Desai, Sujoy Mitra, the Supreme Court had permitted witness examination or witness action through video conference. In Pappu Yadav, video conferencing was used for the purpose of access of accused persons in a fair trial proceeding conducted in a different city when the accused had been kept in a jail in another city. So the history of video conferencing or remote hearings is not new to Indian law. It only requires to be utilized as and when the emergent situations arise, as in the present case. I would definitely not be understood to mean that the fair trial rights of public hearing can be easily substituted by online hearing with the nature of technology that we have today. However, tomorrow is another story, and we live to see newer technology and better opportunities to have the actualization of our rights. I therefore thought that this may be a good opportunity for all of us to deliberate as to whether the fair trial rights are being preserved and actualized in virtual hearings or remote hearings in our jurisdiction. The other fair trial rights are well known, and I will not spend so much time on them. They are the framing of charge, as we have already discussed, a right to expeditious trial, which today has matured not only into a right of the accused, but also a right of the victim to ensure a prompt and quick and effective justice. The right to have legal counsel and legal representation, particularly competent legal representation when an accused is charged with high crime, is another very important factor to be taken into consideration. Recording of evidence in the language known to the accused, his right to lead defense evidence are equally important rights of and fair trial rights of an accused. Autrefoy acquit, the right to silence are important rights, which, however, have undergone evolution with time. Interestingly, right to silence has, in various cases, been subject to severe criticism as to whether the balance and access of fairness really demands an accused not to come up and make a defense statement, making out what is truly and surely within his knowledge, and only relying on the lack of disclosure, and not only rely on the lack of disclosure as an adverse inference against such an accused. This is an interesting area which requires deliberation and development. Autrefoy acquit also in the international fora and jurisdictions have resulted in various changes. In England and in Scotland, Autrefoy acquit is no longer sacrosanct if new and further evidence which were not available at the time when the acquittal had been passed comes to light, and the high courts have the power to direct retrial in certain specific cases. We need to deliberate on these, particularly when in recent times we have seen cases where, after trial having substantially progressed and most of the witnesses turning hostile, in order to ensure the fair trial rights and in order to ensure a just trial, the constitutional courts under Article 226 have directed retrial, irrespective of the stage at which the trial had already arrived at. We should also bear in mind the other important fair trial right as to the right to presumption of innocence. This, interestingly, is not a fundamental right under the Indian law. The fundamental rights under Part 3 do not include a presumption of innocence as a right specifically engrafted as one of Autrefoy acquit or one of right to be informed of his charge and of legal counsel under Article 20 and Article 22 of the Constitution. However, as I said, the civil law rights and the human rights, which have crystallized into international documents like UDR, the Universal Declaration of Human Rights, and ICCP, that is the Civil and Political Rights, to which India is a signatory, make it a part of our international commitments to hold criminal trials where presumption of innocence run as a golden thread in our jurisprudence as a part of just, reasonable, and fair right in criminal trials under Article 21. This, however, is not an absolute right. This right is subjected to the fundamental principle of special knowledge as provided under 106 of the Evidence Act. It is not only in 106 of the Evidence Act, but in many other legislations like the dowry prohibition laws, the 113B of the Evidence Act with regard to dowry death, 113A with regard to abatement of suicide to women, 113 with regard to presumption with regard to aggravated sexual rape cases, as well as under the special laws under Narcotic Act, more recently under Section 29 of the POCSO, and a series of legislations, particularly the latter legislations, where we have seen that the reverse burden in certain cases have been shifted to the accused because of the peculiar nature of offenses. Offenses of dowry death occur within the four corners of the matrimonial home. The evidence is within the special knowledge of the persons who are the accused, namely the husband and the in-laws. In these cases, therefore, the statute provided for a shift of burden when it is shown that the primary requisites of the offense, namely one of demand of dowry and cruelty soon before the death, were established. Similarly, possession offenses like narcotic cases, where the possession is proved, the mens rea is to be presumed for the purpose of coming to a finding of guilt. In these cases, however, particularly the narcotic cases, the statutory provisions of reverse burden were held to be constitutionally valid in Noor Agha, where the Supreme Court, however, made a clear pronouncement of law that the reverse burden, though lawfully permissible, however may be rebutted by preponderance of probability instead of beyond reasonable doubt. Finally, one can say that the reverse burden today is a part of constitutional permissible procedure established by law, which have been engrafted in order to create an even balance in cases where the availability of evidence or the peculiarity of the crime makes the possibility of a prosecutor bring forth and prove such evidence, prove certain facts or ingredients beyond doubt, a patent impossible. These fasciculi of fair trial rights are today, with the evolution of law and certain amendments made on and from 2005 to the Code of Criminal Procedure as well as the Indian Penal Code, counterbalanced with a series of rights available to victims. Victimology in India started developing from the 1980s, when through the constitutional courts and by way of constitutional torts, the victims were provided with compensation in certain cases where the crime had not been proved. One interesting case which comes to my mind is the case of Bodhisattva Gautam, where in spite of an order, in a case of rape, although the evidence had not been proved beyond doubt to bring home the guilt, the Constitution, the apex court, using its powers to do complete justice, had provided compensation to them. In a case where even prior to trial, a rape victim who was a foreign national was provided succor through constitutional tort, in the case of Chandrima Das. The law thereafter developed, and the statutory requirements of acknowledging victim as a player and stakeholder in criminal trial was recognized by incorporating the definition of victim in the Code of Criminal Laws. The definition of victim is an inclusive one. It not only speaks of the primary victims, but also the secondary victims, that is, the ones who have suffered loss and damage and mental agony because of the victimization of the prime victim. Apart from that, one should also bear in mind there are offenses which are victimless. Offense of corruption, offenses against the state does not effectively trigger a loss which is of a personal nature, but the loss is to the collective and to the rule of law itself. And these are crimes which are therefore victimless crimes which partake the character of really causing harm to a civilized living in society and thereby the state. The rights of victims, particularly and most importantly, was the amendment of Section 372 of the Code of Criminal Procedure to provide a right of appeal to the victim. The amendment to Section 24, subsection 8 of the Code of Criminal Procedure to bring in the right of legal representation to the victim, and the recent amendments to the provisions of bail and anticipatory bail, providing for rights of hearing of the victim at the time of grant of bail and ancillary bail in cases of scheduled castes and scheduled tribe offenses, and in cases involving aggravated penetrative sexual assault and rape. The aspects, therefore, in victim rights can be compartmentalized into two categories. The first compartment would be the right of access to justice and fair treatment. That includes the right to know the development in the case wherein the informant is the victim or where a person is a victim. Bhagwan Singh in 1980 was the first clarion call for recognition of such right. If the informant is to be intimated of a prayer for discharge in conclusion of investigation, was clearly pronounced by a three-bench of the Supreme Court. However, Bhagwant was a law declared when victim was not defined in the Code of Criminal Laws. It is also not a case where the right of victim to have a legal representation through a lawyer was also statutorily recognized. In recent times, a judgment of the Madras High Court acknowledged the right of a victim to be notified at the time of discharge or consideration of a prayer for discharge of an. This to me is an important development in the rights of victims to access to justice. The second aspect of access to justice is fair treatment. Not only should the victim be informed of his or her rights as to the developments of the stages of criminal trial, they should also have the right to know, right to participate there. And this is where I would say it is a work in motion. We have recognized the right of a victim to have his own lawyer or her own lawyer. We, however, have not, and that too in a very recent decision of the Supreme Court, recognized the right of the victim to actively participate in the course of criminal trial. Although the victim has a right to participate at the time of hearing of a discharge petition, has a right to have himself or herself heard at the time of bail, has a right to appeal against an order of acquittal. The victim, however, is still today unheard when the trial is in motion. At the time of trial, the victim, through his lawyer, may merely assist the public prosecutor, and at the end of the recording of witness action, may put in his written arguments through the public prosecutor with the permission of the court. The right of the victim to pose questions were not accepted by the Supreme Court in a very recent decision in 2019, and it is a matter to be seen whether this was 2019, volume 17, scale page 75. However, it is interesting to note the Supreme Court, however, did not consider that if the victim had made an application 165 of the Evidence Act to pose questions to the witness, whether such prayer of the victim would be turned down by the court or would not be considered by the court or not. And as I say, this is an area where the law is in flux, and the law would perhaps and surely be developed and crystallized in future. The final area with regard to victimology, or the other area, other aspect of victimology, apart from the access to justice and fair treatment, is compensation and witness protection. Compensation has been today engrafted not only as a compensation by way of restitution under 357(3) at the end of trial, or 357(2). That's part of the fine to be paid as compensation by the accused, by the convict, or compensation simpliciter by the convict upon finding of a guilt. 357 capital A creates the forum or the statutory recognition for the purpose of formulating victim compensation scheme and other rehabilitation scheme for the providing of immediate succor to victim at the interim stage as well as final stage. And in these cases, even if the accused cannot be found or is absconding, the compensation may be available to the victim. This is a very, very positive step which has been taken for the purpose of protection of victim rights and actualization of such rights at the earliest, so that the participation and fair treatment to a victim can be achieved, notwithstanding a long-winded seminal decision, Mahendra Chawla, laid down the parameters of witness protection schemes be formulated in every district in the country, provided for the right of the courts to have a witness in the impact assessment report with regard to protection, and the impact assessment report is to be submitted either by the investigating agency or on the prayer of any aggrieved person, including a victim or a witness. And if the impact assessment report shows that there is a threat to life, the witness and the victim will be put into a category A victim. If it is threat to property, will be category B, and threat to and a mere harassment or intimidation, he will be a category C victim. Depending on the category, the immediacy of the threat, and the impact of the threat on the victim, courts are empowered to pass appropriate orders protecting the identity of the victim through in the course of evidence or even prior to evidence, protecting life and property of the victim by giving police help, police protection, and including shifting of victims to safe houses, and finally providing compensation, including psychological and psychiatric help to victims if necessary. For that, the Supreme Court directed that there should be witness protection program and witness protection committees set up under the leadership of the district judge, the superintendent of the police, and the district magistrate. I would take this occasion to request every district judge to consider the implementation of Mahendra Chawla, because if we do not do this, and if we do not ensure the witness protection, then the purpose of criminal trial would be a mere formality. Finally, I conclude by referring to my brother's request of the impact of compromises, and I couldn't have used a better expression in Ramesh, where in spite of a dying declaration made by the hapless housewife, implicating her husband for reasons best known, and as the judge pointed out, the culture of compromise which is prevalent in communities as ours, all the family members, and mind you, not outsiders, but the parents, the brothers, and other relations, turned hostile in a case of dowry death. So none of these cases where it involves the death of a woman in dowry, and more particularly when there is overwhelming evidence in the form of a dying declaration or otherwise, prayers for compromise, be it at the stage of trial or at the stage of framing of charge, need be countenanced under Section 320 of the Code of Criminal Justice. Similar are the cases of harassment, which I consider a case of secondary victimization, when victims of human trafficking, victims of sexual crimes, sexual harassment are put into the culture of compromise and said that let bygones be bygones and forget the prosecution of someone who may have made a mistake. There are mistakes which are compoundable in law. There are mistakes which require trial to be taken to its logical conclusion. An act of penetrative sexual assault, an act of forcible rape are certainly not mistakes which should be forgotten or forgiven, whatever be the cost. And we must protect our victims from this force, which not always is one of money or muscle power. It is also the force of shame. It is also the force of harassment. It is also the force which is caused by prolonged, protracted, and long-winded trial, embarrassing and harassing cross-examination, and various other methods which are resorted to discourage victims from seeking just succor through our criminal justice system. I think the purpose of criminal trial, as understood in the earlier half of the 20th century, of safeguard of procedural rights alone is not complete. The purpose today is a voyage to truth. And this voyage to truth is under the leadership and under the captaincy of the judge, who, as held by Justice Chinnappa Reddy, is not an umpire who pronounces as to which side played well, but a conductor of an orchestra who sees that the symphony of music is played well and the justice is well served. Thank you very much for your patience and listening to my deliberations on the facets of criminal justice. I would be very happy if it comes to use to you in future and in our daily
Thank you, my lord.
available to the weakest, marginalized, and perhaps the most needy. Thank you.
Thank you so much, my lord. Right of the victim and the right of the society. Fair trial encompasses a larger area. It is not just confined to right of accused, but also it extends to right of victim and the right of society. We had a very interesting comment regarding there are offences which are victimless. that committed against the state, where it is a charge particularly regarding corruption, where the state is the victim, but physically a person does not become a victim, so it becomes a offense of victimless offenses. Then fair treatment to the victim, Mahendra Chawla directives for all the district courts for victim impact assessment report. These were the highlights. Apart from that, Praful Desai, Papu Yadav case, Bodhistava Gautam, these were. Thank you so much, my lord. And coming back to the question,
Yes.
interactions, my lord.
Yes, Mr. Chaudhary, I received a few questions from Justice Sen in the afternoon.
Yes, my lords.
I think one was with regard to contradictions, how one
Yes.
records contradictions with regard to previous statements.
Difference between contradiction and discrepancies and inconsistencies.
Right. So far as contradiction is concerned, I do not think the law could be better enunciated than what was done in Tahsildar Singh, AIR 58 Supreme Court. Tahsildar Singh makes a very, very clear enunciation of the law that what you have to do when there is a contradiction and what actually is a contradiction. Although proviso to section 162 says that omissions of material particulars would also be contradictions, omissions by themselves cannot be treated as contradictions when you take the contradiction as in terms of Tahsildar Singh. Like in Tahsildar Singh, it was said that ABC murdered D. That is the previous statement of a witness. And when the witness comes to the box, he says D and E or X and Y murdered D. That amounts to a contradiction. And there you have to confront witness with the previous statement by saying, did you say ABC murdered D? If the witness admits it, it is proved and no further steps need be taken. But if the witness does not admit it, you have to prove it through the investigating officer and mark that portion of the statement which is in contradiction to the evidence already.
Yes, my lords.
This is what Tahsildar Singh says. An interesting offshoot of this is then how do you prove omission? Like let us say someone said A and B murdered C. Or rather someone said that I saw X walking down my road beside my house. Then when he comes to the witness box, he says, I saw X walking down the road carrying a basket. Now that carrying a basket is a contradiction, it is an omission. And for the omission, you cannot prove the entire statement. And this is decided in Lakshman, 1974 Supreme, where Justice Beg makes the distinction between how to prove an omission in relation to a contradiction. A contradiction is one where one statement cannot survive in the existence of another. Like if A murdered B, then in witness box he says X murdered B. X murdered B cannot survive. But I saw A walking down the road the day of murder, and in witness it says I saw A walking down the road with a knife on the day of murder, is an omission of with a knife and is not a contradiction. Now it will become a contradiction if it is a material omission. To prove this omission, you need not prove the entire statement, because then you will have to prove the entire statement, which is impermissible in law. It is impermissible in law as per 160. And that is what Lakshman in 74 elucidates Tahsildar. And my answer to the question is this. The other question is a very interesting question with regard to 319 of the Code of Criminal Procedure. My friend, the learned judge who has given the question, is absolutely right in making this observation as to whether, how can the prospective accused be heard? Order is passed under 395 CRPC. 319 CRPC envisages the attendance of a person who is not in attendance before the court. So if he is not in attendance before the court, the question of giving him an opportunity of hearing perhaps becomes problematic. The issue or the trouble in my friend's mind is perhaps because of an observation made by the Supreme Court in Jogendra versus State, 2015 9 SCC 254. In Jogendra versus State, the bench was considering whether a person who has been summoned under 319 CRPC and a charge is being framed has a right to seek discharge or not. While going into this question and holding in the negative that he does not have the right to pray for discharge, the apex court has made an observation that he will not have a right to pray for discharge for various reasons. One reason is the level of satisfaction for summoning the accused under 319 is much higher than 204. It is the satisfaction of framing of charge, and therefore he cannot seek discharge before the same court who has come to the satisfaction in that way. His only answer is a judicial review by decision. And then the reason that he may have necessarily been heard. I would, with respect and due humility to the decision, say that the issue whether the pre-trial or pre-summoning accused under 319 can be heard or not never fell for decision in Jogendra. And that is an observation of the court, which was not a matter in issue and was neither argued nor decided, and therefore has to be seen in that perspective. The very wording of section 319 will not permit an accused to be heard before he is summoned under 319 CRPC. On the other hand, as in 202 CRPC, if he gets to know of such a situation, he may intervene and may participate, may watch the proceedings. But it is a matter of serious consideration whether he should be heard or not. Definitely, he has a right to challenge the order before the Court of Session. Since we are under 319 CRPC, another judgment of the Supreme Court I would like to point out is Deepu versus State, where an accused was summoned purportedly under 319 CRPC, and Supreme Court upheld the order, although the accused had been made an accused in a supplementary charge. The question was, the accused was discharged. He was charge sheeted. He was discharged by the sessions judge. Matter went up to the Supreme Court, and the order of discharge was upheld by the Supreme Court. In the meantime, a supplementary charge sheet was filed implicating him as an accused. And on evidence, he was summoned as an accused under 319. The Supreme Court has upheld this order under 319 CRPC. This, however, goes against the earlier judgments of the Supreme Court that that a person who has been accused or who has been charge sheeted and discharged under 229 or 239 of the Code of Criminal Procedure cannot be summoned under 319 CR. The judgment is Sohan Lal, AIR 1990, Volume 4, SCC 582. Sohan Lal. Now, Sohan Lal was not considered. However, considering the fact that a supplementary charge sheet had been filed under 173(8), I think the order of the sessions judge would have been upheld under 204 IPC, 204 CRPC, as in Dharampal. As in Dharampal, because agency by way of a supplementary. When an accused has been made, when a person has been added as an accused in a supplementary charge sheet, question of invoking 319 really does not arise. So Tipu is another case which has been decided in the facts of the case where a supplementary charge sheet has been filed. Perhaps may not be considered as an authority for the proposition that if an accused is discharged by a court after being charge sheeted, whether he can be summoned under 319 CR. This is what I thought that of my own volition I would like to make certain comments. The other judgment, other question which was posed was with regard to the non-production of an X-ray report. The issue is, in this case, the trial court ought to have exercised its power under 91 CR and ensured the production of the X-ray report. Without the X-ray report and the evidence of the radiologist, the opinion of another doctor who did not conduct the X-ray perhaps may become hearsay. Because he is not the doctor who is examining the X-ray, who has conducted the X-ray, and he is giving an opinion. So at best it can be an opinion evidence. And in the absence of the primary evidence which was available, it is to be seen in the light of other evidence whether the conviction under 325 IPC may be upheld. But then this, as I say, is a matter of appreciation of evidence, and there may be contrary views. I would put a caveat. So these are my responses to the questions which were sent to me.
Thank you, my lord. We have one last question, my lord. It is about the predicament a court faces when the case is regarding unnatural death of a woman within 7 years of marriage. So at the time of framing charge, sometimes the picture is not clear whether it is 302, whether it is 304B, whether it is 306. So the question, there are different judgments of the Honorable Court. In one of the judgment, Honorable Apex Court said that in all 304B case, charge under 302 has also to be framed. Then we had last year, 2018 Gurnaib Singh case, where said that it was not mandatory. But this predicament is there, this regarding framing of charge, regarding 302, 306 and 304B. My lord, we will love to hear something on this issue from your lordship.
I would, so far as framing of charge, Colonel Singh must be understood in its proper perspective. What I mean to say is, Colonel said that don't be mechanical in framing charge. But in cases where there is a clear prosecution case of suicide within 7 years, you can frame charge under 304B, 306. Need not frame charge under 300. But where the cause of death is unclear, namely like poisoning, there is no suicide note. Poison may have been administered, poison may have been taken by the victim herself. It will always be safer to frame the most grave charge in the alternative. That is 302, 304B and 306. But then what Colonel said is, don't follow the earlier judgment of the Supreme Court like a gospel truth or an mechanical imperative. If the facts of the case are clear that it can never transcend into 300, there is a clear suicide note, and the postmortem report is only indicative of suicidal death, then you may not frame a charge under 300. That will not render it a mistrial. But cases where you have doubt as to cause of death, cases where you have the possibility of the graver charge being brought in, it is always better to frame a charge at the highest level and then conduct the trial. The reason is expeditious trial. If you at a later stage frame a charge, then again you will have to recall the witnesses for re-examination if the graver charge is framed later.
Thank you, my lord. May I request, my lord?
Yes, Mr. Chaudhary.
May I request your lordship to give the concluding remarks, my
We had a very engrossing session of more than an hour. I think the time was very short, and we could have easily spent the whole night hearing Honorable Justice Jayamalla Bakshi, a speaker par excellence. I thank Jayamalla Bakshi, Honorable Justice Jayamalla Bakshi, for giving his precious, valuable time to us. Very recently, it's only 1 or 2 days back, the Hurricane Amphan ripped apart Calcutta, and there was massive destruction in and around house of our Honorable Justice Jayamalla Bakshi also. His internet connection was shattered, and in spite of that, he made Herculean tasks so easy, and because of his love for us, he got connected with us. I thank Honorable Justice Bakshi from core of my heart, on behalf of the Judicial Academy and behalf of all the judicial officers who had participated today.
Thank you very much, and a very good evening to all of you.
I thank all of the participants, and I hope they are leaving today with some knowledge and gaining some knowledge as I have done. And I also thank our Judicial Academy, our Chief Justice, the Honorable Justice H.C. Mishra, who has helped a lot in hosting this webinar. In future, we will have several more like this, where we will learn and we will have some exchange programs also, as Honorable Justice Bakshi was narrating yesterday. I thank you all. And I thank you all the guests, the special guests who are here, and all the guests who have joined here. Thank you very much.
Thank you very much.
Thank you, my lords. Thank you so much. Thank you.